Hello friends, welcome. Today I am recording this part 2 of the video series titled Supreme Court's AGR Judgment. Now a couple of days back I recorded the part 1 of the video series wherein I took you through of all the events which took place from 1999 till 2019 when the final judgment was delivered. Now this issue emanated from the fact that the Indian telecom operators were arguing before the court that the license fee that they are supposed to pay should include the non-telecom portion of their revenue as the part of the AGR, which is called adjusted gross revenue. Now DOT collects from the Indian telecom operators a license fee which is a percentage of their revenue. Now, excluding the non-telecom portion of the revenue led to a shortfall as regards DOT from the point of view of their collections since 1999. Now, what Supreme Court said in 2019 that all these shortfalls which happened since 1999 has to be replenished by the operators, and DOT is well within this right to collect not only this shortfall but also along with it interest as well as penalties. This led to a outflow of to the tune of $27 billion, impacting the overall health of the industry as well as the operators' ability to invest in advanced networks technology like 5G and expanding their networks beyond what they are already doing. So this is the context of this overall discussion. In this part, I am going to be focused only on the mistakes which were committed by all the stakeholders who are involved in this legal tussle since 1999 and even till date today, and what we can learn from these mistakes. Now it's very important to understand this because devil is always always in the details. So without wasting any further time, let's go into the mistakes. The first mistake was committed by DOT when it announced the migration package. Now, for the readers who already are following the telecom sector from the beginning will know that before 1999, the operators were paying license fee which was fixed in nature. Now, because at that moment, most of the operators who are undertaking operations in India had faced huge financial crunch. So the migration package was offered by DOT in order to relieve their burden and to migrate them into a license fee regime which will extract license fee proportion to the revenue these operators will generate. In this manner, the idea was that the telecom industry can contribute towards the development of the country and contribute towards expanding mobile connectivity in remotest part of the country. Now what happened was, when the migration package was announced, it was accepted unconditionally by the telecom operators. Now if you see this is the acceptance letter. But when the offer letter was given, there were two items which were mentioned, that the license fee will be collected as the total revenue as a percentage number which the DOT had decided temporarily as 15%. But the definition and this percentage will be decided later through a open consultation held by TRAI. So the mistake number one, again I repeat, that the definition of total revenue, which is the bone of contention in this legal tussle, was kept open and was to be decided through an open consultation by TRAI, was the expectation which was set by DOT before the operator. Though it is important for the DOT to fulfill these expectations. So let's see what happened next. Now the next mistake which DOT committed is that though it allowed an open consultation to be held anchored by the TRAI, but it did not allow the consultation process to be done in a transparent fashion. When I mean by transparent means all information required for DOT to deal with this issue should have been placed before it, so that the whole process is done in a holistic manner without anything being left out. So when the consultation was going on, DOT hired a consultant and privately held a consultation. I will not call it consultation, a discussion, so that the consultant can advise DOT that what the revenue share definition would be, means what will be the definition of the total revenue. And that report of the consultant was not placed before TRAI. So it kind of created an opaque situation and led to a situation where the transparency of the overall process got impacted. Now, when the TRAI gave its recommendation, DOT did not agree with the TRAI definition. Now, if you look at this particular document, it is the TRAI response to DOT's back reference on 31st October 2000. Now, when DOT does not agree to a TRAI recommendation, where TRAI said that, look, the total revenues definition should have to be bucketed into two different compartments. One will be the portion where license fee will be charged, another will be the portion where no license will be charged. But DOT disagreed with this definition and said that it wanted to charge the license fee on the total revenue. The logic given by the consultant was that if it allowed the revenue to be bifurcated into two different compartments, then the operators can adopt manipulative accounting, which might lead to loss of revenue. But this point was never discussed openly in the public domain. So what the operators thought? They thought that there is certain information which is being deprived, and the whole process, since it is done in an opaque fashion, something unfair is happening, because they were of the opinion that the revenue that is getting generated out of the activity that they are doing, which requires license as per the Indian Telegraph Act of 1885, should be licensed. And the activities like interest payment, property rent, foreign exchange fluctuation, many things, there are a host of items. Those did not require any license as per the Indian Telegraph Act. Therefore, there is no point in charging license fee on that bucket, which is called non-telecom in nature. So that was the bone of contention, and since it was not done in a transparent fashion, so that is the foundation of this dispute, and the operators filed cases in various courts of law. Now, what happened next? What happened next was much more, it actually added fuel to the fire. The reason is that when the TRAI gave its recommendation, it should have asked DOT at least that tell us what is the rationale for you to decide the definition of revenue as total revenue, all inclusive, including the non-telecom portion. But they did not ask. If you look at this particular document, which is shown here, which is an extract from the TRAI's Act, and there is one paragraph which I have blocked on with red, encircled with red, you will find that it is very clearly specified in the TRAI Act that TRAI has full powers to ask for information, additional information from DOT, and DOT has to provide the information. So neither TRAI asked nor DOT provided. So that actually created further opaqueness and added fuel to the fire. And it created a confusion in the minds of the operators that, the whole process is done in an unfair fashion, and they are being asked to give license fee on the portion of their revenue, which has got nothing to do with telecom. Now let's go to the next mistake. The next mistake is even more severe, and actually it shows total confusion that happened in our legal system. And let me explain what I mean by this. Now, if you look at this chart is very simple to understand. So in this particular block is the the TDSAT judgment which it delivered on 2007, and this block is the Supreme Court judgment which it delivered on 2011. Now, what I am basically trying to say is that when the matter went to TDSAT, because both party, DOT as well as the operators, disagreed on the definition of license fee, then TDSAT came out with its judgment. And before it came out with this judgment, what it did is it ordered DOT that the consultant report, which it did not submit in the earlier consultation process which the TRAI held, now you should place the consultant report before TRAI. So TRAI took the consultant report, then invited inputs from all the stakeholders and held a open and transparent consultation and fed that report to TDSAT. Now TDSAT, based on the report, decided on which line items should be included in the bucket of non-telecom revenues and which line items should be included in the bucket of telecom revenue on which the license fee will be charged. So when that decision came, DOT became an aggrieved party. DOT then went to Supreme Court, and the Supreme Court heard both the parties and gave a judgment, gave a order. Cannot be called as judgment, but it is an order. Now what it is saying, it is basically part of the TRAI's judgment, an extract here of the Supreme Court's 2007 order, which says that heard the party pursuant to the direction of the TDSAT in the impunch order, a fresh recommendation has been made by TRAI, which I already told you. In view thereof, we see no reason to interfere. Means Supreme Court did not interfere, and it says the appeal is dismissed, but with a caveat. And this caveat is extremely important for the viewers to understand. The Supreme Court is saying the appellant is, however, given the liberty to urge all the contention raised in the petition, means the petition that DOT raised before Supreme Court, before TDSAT. Now look at the fallacy of the situation. This is really very unfortunate, and I'll be very honest with you. I find this whole thing so unfortunate, and we'll understand as I take you through this whole process. Now TDSAT already had heard the DOT, it had already heard the operators, and the same issues got raised before Supreme Court, and Supreme Court is saying that please go and raise the issues again before TDSAT. Therefore TDSAT said that since I have already heard you, what is the point of revisiting the whole issues again? And therefore it basically said that though Supreme Court is saying that DOT has got full liberty to raise all the issues before TDSAT, I will not raise the issues, I will not consider those issues which has already been discussed before TDSAT in the earlier process, which culminated into this judgment of 2007. Therefore I dismiss your petition. That was the point which TDSAT. It looks quite fair. But the problem was that there were two different issues here. One issue is that when because the matter again went to Supreme Court, and Supreme Court gave a judgment in 2011 where it quoted this fact, this line which is dotted line which I basically showed you, that it says that we had given a order to TDSAT to hear the petition of DOT again along with the operators based on the report which the TRA has given, recommendation which TRA has given. But you didn't do that. So it was mentioned as one of the reason of rejecting the operator's appeal in 2011, and said that this is one of the point of consideration because TDSAT did not follow the process. And in that judgment, it also rejected the jurisdiction of TDSAT. It said that TDSAT actually doesn't have a jurisdiction, which might as well was possible in 2007 itself. So I think that is another big mistake. And let me explain as I go to the next slide what actually transpired. Now what SC did, as I told you earlier in the earlier chart, that it had the opportunity in 2007 to look into the matter in a holistic fashion, that who has jurisdiction, who has done what problems, and everything could have been discussed. But he did not decide to interfere at that particular point of time. So it might have been because of many reasons. I don't want to get into the legality, but I am basically making a simple point that if it was a jurisdiction issue at that particular moment when TDSAT was dealing with this issue between the debate, that the tussle between the operators and the DOT, then Supreme Court might have decided the issue in 2007 itself. Now let's understand what was the argument that the Supreme Court made in its judgment of 2011. Supreme Court said a very simple point which is legally very sound, by the way. It said that DOT is a licensor and the operators are licensee. Now DOT, being a licensor, has got full powers to decide the conditions of the license. TDSAT cannot decide the condition of the license. TDSAT can only interpret the terms of the license if there are some ambiguity in the language. So by giving a judgment, TDSAT of segregating telecom versus non-telecom into two different compartments, TDSAT fiddled with the conditions of the license, which it is not allowed to do so, right? So this was a very sound logic which Supreme Court used by dismissing the TDSAT's jurisdiction, and therefore considered the whole process as null and void, and that made the operators' decision go completely upside down, because operators were winning till the time the TDSAT judgment came. But when it went to Supreme Court, the whole thing fell apart. But there was one more problem. Supreme Court in 2011 did not look into the specific of the operator's demand, means which line item should be excluded, which line item should be included in the telecom bucket, and which will be in the non-telecom. Those details were not discussed. What it basically said is very simple. It says that, look, contract cannot be changed by TDSAT, but TDSAT can interpret the conditions of the contract, and therefore it should look into those specific demands of DOT to collect license fee and say that whether those demands are legally sound or not, or as per the contract or not. So the whole thing from in 2011 was sent back to TDSAT again. Now this created a ping pong ball of situation. So TDSAT did look into the matter and gave a judgment, but that judgment was basically excluded and thrown in the dustbin, and it asked to look into the specific demands. So it is very, very, I would call it, not, I don't know how to basically describe the situation. It's kind of created a frustration in TDSAT, because both the things, whether you decide non-telecom versus telecom, or whether you decide individual line items, whether it should be falling the part of the bucket or not, is almost one and the same thing. So it kind of created some confusion, and it lingered the overall legal tussle for a longer duration of time. Now, what was the next mistake? The next mistake was in the 2011 judgment. Because in 2011 judgment, which what Supreme Court did, it looked into various questions which required legal scrutiny. So what were the questions? There were four major legal questions. The right of DOT to re-agitate issues post TDSAT decision on 7th July 2006, which I have already explained to you. So if TDSAT gave a judgment, whether DOT has the right to agitate that judgment before Supreme Court. TDSAT's jurisdiction over the license term and condition, which I already explained to you. Finality of TDSAT order in favor of the licensee without DOT's appeal being heard, which was this particular point, this one, because the TDSAT, Supreme Court already said that you have to re-hear DOT, but they didn't, right? Then, licensee's right to challenge the AGR competition, its timing and its grounds. But it excluded one very important aspect of legal, which was also probably of legal nature, which is transparency. The process of implementation of a particular regulation in a transparent fashion. Now, DOT has the right to reject TRAI's recommendation. Absolute right, because that is the law of the land. But DOT has to give some reasons, right, on what basis that recommendation is getting rejected. So that reason DOT never gave in the initial stage of the process itself. So if DOT had provided the reason and put across the consultant report right before TRAI in the beginning part of the process, when the consultation was happening just after the migration package, then the operators would have got opportunity to contribute to the whole process, and they could have understood what the DOT's mindset is. Maybe there at that particular point of time, the operators would have convinced DOT, or DOT could have convinced the operator, the matter would have settled and it would not have lingered for such a long period of time. So this important issue, which is of legal nature, of transparency, fairness, was excluded in the 2011 Supreme Court judgment as a question of scrutiny. It should have been done as per my personal view, and that resulted in a prolonged legal battle lasting more than 20 years and the loss of $23 billion. Now, let's go to the next mistake. The next mistake happened in the October 24th October 2019 Supreme Court judgment. Now, in this judgment, Supreme Court established the right of DOT to collect revenue on the collect license fee on the total revenue. No problems with that because DOT has got full right. So Supreme Court has said that. But Supreme Court actually imposed interest and penalties and attributed all the delays on the head of the operator. Now, an attentive viewer who is listening to this presentation would clearly understand that the delay was actually not on the head of the operator. It was very unfortunate. The process was being, thrown into every stakeholder's, court, and it was not been dealt completely at a time when the opportunity was there by the legal entity which was dealing with that particular issue. So it was not completely the operator responsibility that the issue got lingered for such a long period of time. So therefore the question of imposing penalties and interest on a principal which is just fraction of the total outflow of $23 billion looks to be a little bit more not very fair to me, right? So that actually created a problem because the overall outflow of $23 billion, 70% of it, more than 70% of it is interest and penalty. And that too, again, the principal, which is 30%, also the calculations were not being considered properly done by DOT, by the operators, which we will talk in the next subsequent mistake. So let's talk about that. So here we are, and now let's talk about this, which is mistake number 8. Now, in the same judgment, what happened was that Supreme Court got a perception that the operators are lingering this case, not, willfully, means they don't want to pay. The perception, that was the perception of Supreme Court. Therefore, Supreme Court asked DOT that you provide us with your calculation is what are the dues which you think, means DOT thinks that the operators have to pay. So that was the preliminary assessment which the Supreme Court asked DOT to provide. So DOT gave the preliminary assessment, which is the amount which I told you, $23 billion. So that preliminary assessment became part of the judgment. But unfortunately, this preliminary assessment became the final assessment because Supreme Court became so paranoid about the fact that the operators are pushing this legal battle in a manner that they don't want to conclude it. Therefore, it forced the operators to conclude the process then and there itself. So it basically said that the demand raised by the Department of Telecom, expressed for AGR, based on the judgment of this court, there shall not be any dispute raised by any telecom operators and there shall not be any reassessment. Now you ask yourself, if DOT is doing a work at the first instant and basically putting across their demand, like even income tax department is putting a demand before you, there could be some mistake there which might have been done inadvertently because such a long process, such an old case. So it is the responsibility of the DOT and the operator sit together and finalize the demand. So that was a natural justice should have been followed. Supreme Court could have said that, look, in 3 months, you guys decide what the final demand is. Talk to each other and decide the final demand. It should not have been done one-sided manner. The DOT gives the demand and Supreme Court basically makes that final. So I consider that as mistake number 8. Now let's talk about the telecom operators. Now telecom operators, actually, if you ask me, they also committed a lot of mistakes. The problem was that the telecom operators did not do any risk management. Now let's say if I have been fighting a case in the court of law and I'm winning, let's say, but as a company I will secure the downside. It could be that even there is a 1% chance of losing. I should take a proactive step to prevent that outcome impacting my company. So what is that? So if there is a substantial portion of the non-telecom revenue which is emanating from businesses which could have been put in the name of a different company, excluded out of your license company which is actually having the license, at least that part could have been done rather than including everything. Even PSUs, I will basically do a separate video. PSUs were aware of the fact that it was being fought. Some of them were party to this dispute. They also did not create a separate company and put all their telecom business into the separate head. Rather than basically later that the Supreme Court had to give some kind of a respite to PSUs. which also is debatable, which I'm going to talk in the third part of the video. So there were many missed opportunities. The second important missed opportunity is the whole process of charging license fee. Now, as the license fee was decided at the time of the migration package, you probably are aware that the revenue share mechanism of charging license fee is not a practice followed anywhere in the world. And I will do a separate video to explain this fact, that why it is a very inefficient way of charging license. Now, it was done because the situation demanded like that, the license fee was supposed to be charged like that, because there was no other mechanism available. But after a period of 4 to 5 years or 6 years, the telecom industry became very stable. So, charging license fee on a paper document which has bundled bottleneck resource attached with it, but the quantum of that bottleneck resource, which is spectrum, was not specified clearly. So the value of the license actually was very vague. So in rest of the world, if you go, they don't basically auction licenses or charge license fee on permission, because when you charge license fee or permission, it's a very inefficient way of managing or doing regulation, because that does not give any benefit. What DOT should have been done is charge money on bottleneck resources, because that bottleneck resources, the purpose of the bottleneck resources, which is scarce, should be efficiently used. So the operator should have advocated before the DOT, before even the 2G scam came in, that saying that, look, dismantle this process of license fee. Now we are going to participate in an open auction and pay for spectrum in open auction. And that could have avoided not only this whole process about this, bucket of telecom versus non-telecom, but also the 2G scam and all those outflow and all those inefficiencies which the telecom industry has to face. So that was mistake number 9. Now, I just want to conclude, because the video is going very, very long. So if you look at, a attentive viewer might already have concluded this whole debate which happened between the operators and the government. See, it was not the question of legality. It was basically the question of fairness. And it is a question of perception. Now, if DOT as a licensor had all the right to decide what the condition of the license is not disputable at all. Everybody knows about it. But as a licensor, it is my responsibility to act fair, not only act fairly, but perception that I am acting fairly is also very important. So, but that perception was never being made across in the beginning itself, which basically laid the foundation of this case. Otherwise, the case could have been settled amicably long back. And then imposing penalties and interest on the operators on account of delays is a wrong thing to do, because as you saw that the delay cannot be attributed to all the delay cannot be attributed to the operators, and the operators not arguing with DOT to settle this case long back and not doing risk management. Multiple companies were there for some of the operators paying loans to each other, and that interest become part of the bucket of license fee, because that become revenue for a particular company, and the license fee was charged. Those restructuring could have been very easily done. So I believe that it is basically a learning experience for all of us, whoever is watching this video, going forward, that in order to prevent all this legal battle, each and every stakeholder involved in this process has a responsibility to behave responsibly. Now, if you don't behave responsibly, you are actually doing injustice to the nation. Because who is getting impacted in the whole process? The nation is getting impacted. The consumers are getting impacted. The resources which are basically, very, very scarce because those resources are being inefficiently used. A lot of spectrum lines vacant, nobody uses this. Because of the 2G scam, a perception is there that if you reduce the price of the spectrum, it's a loss to the nation. But nobody talks about the loss to the nation because of 50-60% of spectrum lying unused. Those could have been used and the consumer would have got better services. The cost of the license fee could have gone down, the operator would have been more empowered, the competitiveness of the dynamics of the industry would have been much better, the rural area would have been connected because lower the cost, better the operators are empowered to extend the connectivity to the remotest part of the country. All those were missed opportunity. So in the end of the day, I would just like to say one important thing, that we have to learn from our mistakes, and going forward, you have to prevent such mistakes so that India as a country is able to march ahead in the 21st century and become a developed country. we should lead the nation, and we'll show that we are able to manage things much better than anybody else in the world. That's all. Thank you for the video has gone very long. Sorry for that, but it's important for you to convey this important event so that you understand the nuances of this judgment. Right? Thank you for your patient listening. Thank you very much.